we have only 10 judges. As against the statistics that they have provided there itself. In Australia, they have 41 judges per million. And in Canada, they have 75. In England 50, and in USA 107. Now it is suggested thereafter in judgment of the Supreme Court that we must now proceed further and have at least 50 judges per million. The problem which poses immediately is if we have as less, in fact further statistics analysis says that it's actually not 10, it's only actually 8. The simple point which comes out of this is that we have less number of judges, we have far number of cases which are pending. Enough research is done with respect to the total number of cases pending. But we have staring in our face a situation where we have virtually 10 judges per million. The solution, first question that should arise is if there are so few judges available, should we not have more? That's a straightforward question that anyone would ask. If we are to have more number of judges, then it throws up yet another question. That's the question of resource. Now, how do we afford more number of judges? It involves a lot of finances. Now, what has been done with respect to employing more number of judges in the higher judiciary as well as in the lower judiciary? Then, if you look at how we have actually considered this issue for the last 50 years from the advent of the Constitution, what is very surprising is that judiciary never occurred at any point of time in the planned process at all. Judiciary till today is only a part of unplanned expenditure. That is one difficult issue. The problem that arose because of this is that the executive did not really have an opportunity to consider what really the problem with respect to judiciary. The latest statistics show that the amount spent on judiciary was 0.071%. 0.071% with respect to the total plan outlay of 8,93,183 crores, which works out to even less than 100th of the budget. With so little resource that has been allocated to the judiciary, how is it possible that we dispose of cases with few judges available to us? Other solutions have actually been seen, like computerization and methodology of disposals and so on. All this apart, but then there are human limitations. A judge cannot dispose more than what he can. And if you are forcing a judge to pay, going by statistics and asking a particular judge to show more disposals, then definitely it affects the quality of the dispensation of justice. Simple, straightforward point is that we need more number of judges for which there are no funds. I think the time has come to raise a very fundamental question. Under the Constitution, allocation of funds is the exclusive power of the executive, of course, to be approved by the Parliament. Now, this power that has been given to the executive is to ensure that other branches of the state are equally supported so that the purpose of the Constitution are advanced. Should we not be asking this question? Should the executive control the finances in such a manner that it would virtually render the functioning of the other branches of the state very difficult or delayed? That question has not been raised. I think it is really time has come to raise this question, because the power that the executive exercises is coupled with the duty under the Constitution to ensure that all branches work in furtherance of the Constitution. And an issue arose in a matter pending before the Supreme Court in a public interest litigation where the states were asked, is there any necessity to create more number of subordinate judiciary in the courts? Affidavits were filed by all the states, and invariably every state has said that there is a compelling necessity actually to create more number of district courts and subordinate courts. But then they had an idea to it. Immediately they said, however, so far as we are concerned, though we need judges, we need courts, we cannot afford. Central government should provide for the money. This again throws up yet another two more questions. First is, once you recognize that there is a compelling need to establish courts, can you take the plea that you do not have the resource? It may be a reality, but then the question is that what effort has been made? That's a different matter. Because access to justice has been recognized constitutionally world over, that it is a fundamental right, and that you do not have the resource is not an excuse when a person seeks to exercise his fundamental right. Even assuming for a minute that it is perhaps not possible for states to raise resources for establishing that many courts that it wants. Now the second question that would be is, even assuming there is an obligation, then whose responsibility? If we are talking of courts in the subordinate judiciary, the plea of the state is central is that it is a state subject. So therefore, only the states has to bear the burden. This is yet another myth which has continued for a very long time. On this aspect also I would like to indicate, before I go to the second point which I want to make. Earlier, dispensation of justice was exclusively in the state subject under entry number 3. But by the 42nd Amendment, the list 3 has been amended, concurrent list, and a new entry has been introduced, that is 11 capital A, which puts an obligation on the center also for the purpose of establishment of subordinate judiciary. So therefore, it is no more permissible for the center to state that so far as subordinate judiciary is concerned, it is only for the state to take care, we have nothing to do about it. There is another article which has not been examined till now, Article 247, where it specifically says that the Union shall establish subordinate judiciary for the purpose of dispensation of justice with respect to matters connected with central laws. In our judicial system, we do not have separate hierarchy for federal legislation and for state legislation. The courts are common. If these district courts are to dispose of matters relating to questions arising out of central statutes, then there is definitely an obligation on the part of the center also to see that this subordinate judiciary is established and it has a duty to fund the subordinate judiciary. This aspect has also been not considered in the recommendations given by Justice Shetty Commission. They have enlisted as many as 340 central statutes. These central statutes, Convention for Evidence Act, IPC, whatever, the TADA Act, which is now repeated, very many acts, these are all central statutes, these are not state statutes. Now, if these proceedings or issues arising under these central statutes are to be considered by a subordinate judiciary, even including the criminal courts, how is it permissible for the center to say that we have no obligation to fund the subordinate judiciary? This 350 central statutes, the amount of litigation that arose out of these central statutes are phenomenal. They have done a detailed study of that. the impact assessment has been done. So it is impermissible actually for the centers to say that subordinate judiciary will not be funded. Very casually, once in a while, some amount is released for the purpose of establishment of what is called a fast track court, and they say it's only for a period of 5 years, and after that the matter comes to an end. Now, in fact, we must insist, either through a fora or by judicial proceedings, this aspect has to be examined. First of all, I am repeating the point before I conclude it. First of all, can it be said by the executive that they do not have the funds and that it is not their obligation at all? And legally speaking, it is their bounden duty to ensure that judiciary is actually included in the planned process. There are two matters which went on before the Supreme Court in which undertaking was given by the center, stating that they will include judiciary in the process of planning, in the annual planning as well as the 5-year planning. One of the recent notifications issued by the Finance Ministry asked all the departments and all the ministries to give a list of the aspects which need to be considered for the purpose of preparing the next 5-year plan. There is no indication either to the law ministry or to any other ministry what is it that you need. Because according to them there is a conception that judiciary is not an institution which generates wealth, or it is an institution which is having a social obligation like the Department of Social Welfare and so on. This conception is totally erroneous. This myth has to be busted. Earlier, any society which has a credible justice dispensation system actually promotes wealth. It is a wrong assumption that by merely disposing of family matters or other matters, there is no generation of wealth. In fact, at the time when they had established these tribunals in the banks for the purpose of disposal of matters before the banks, they have said that earlier disposal is actually creation of wealth. So the faster you dispose of matters, the more that you create wealth. So insisting that the judiciary must be included in the planned expenditure and allocation of substantial funds, when you start involving the judiciary, automatically there will be a compelling need to increase the amount of money which is allocated to judiciary. The second aspect which I wanted to indicate is, I'm concluding this. I'll just indicate and conclude the second aspect of it. Second aspect relates to the court fees aspect. We have had traditionally a conception that court fees must always be kept to minimum. So therefore, again, there is no resource. The Law Commission's 2 reports yet again say that court fees should not be increased. This conception also has to be changed. There are instances like the recent electricity tribunal has the court fees of 1 lakh. We must have a regime where the presiding officer will have the absolute discretion to say that I will waive the court fees in a particular matter. But where the client is actually willing to pay for an early disposal, we must insist that there must be a change in this process of court fees. With a very liberal regime is what my suggestion is. The third thing is, for an early disposal, we must now start thinking about formulating times for argument. We must indicate, we must have a research team to indicate, to send word to the counsels whose cases are coming up for hearing and indicate what time it will take, what time the respondent should be scheduled, tabulated, and counsels will surely do it, and they have done it with success in a number of cases. If this system is implemented, we can actually experiment with it. These are the 3 aspects which I wanted to indicate. Thank you very much.
Now, Mr. Dr. Chavan will speak.
And distinguished speakers, Mr. Judicial, Mr. Jain, Mr. Nathuma, Mr. Abbasi, and young student, we are deliberating on large delay and the reasons for those delays. I remember remember about 22 years back, I organized a conference in Delhi University. Dr. Bhardwaj, he then was law minister. He spoke and he said, delayed justice is denied justice, and justice hurried is justice buried. First aspect, all the speakers have dealt. I think the second aspect I will try to deal with reference to the cases which I have personally handled. If we see the way the Constitution bench cases are decided in Supreme Court, in fact, they are responsible for the institution of so many cases. I agree with Mr. Sushil then that because of the confusion in the Supreme Court, the institution of cases in the lower courts and which pile up to Supreme Court is increasing. A constitution bench is deciding an issue, a dissenting judgment is there, but the majority judgment doesn't deal even by a single line the dissenting view. And a division bench is dealing with the issue ignoring the constitution bench. Even the constitutional provision. So the Supreme Court, when it is deciding an issue with respect to the Supreme Court, should decide in such a way that the constraint of the legislation and the effect of all the future litigation should be considered. While preparing for MP's expulsion case, I see in the US Constitution there is a provision for expulsion of MP. But still the US Supreme Court has restored the membership of 2 MPs. And in the Indian Constitution there is no provision because disqualifications which were stipulated in the provisions of Article 102, they didn't include expulsion as one of the disqualifications. We argued, I think, quite a lot, but all those things could not materialize. And the basic principles which were involved, the dissenting judgment which was given, that was not at all considered by the larger composition of the bench. Then recently we had a case where there was a protection by a 9-judge bench in Indira Thani case. Thereafter, the constitution was amended. The division bench has decided in a way that the protection which was given by Indira Thani, even that doesn't exist. Even the constitution was amended for that purpose, as a beneficial legislation and to give a wider interpretation to the constitutional provision. Even otherwise, the interpretation which was given by the Supreme Court was not really correct. But even otherwise, if we assume that is correct, but still with the protection which was given by a larger bench of 9 judges, that cannot be taken away by a smaller bench. If that was to be overruled, perhaps the 11 judges was the only remedy. And the hiring system in Supreme Court of deciding cases, that if a case is coming there, we will just decide it without examining all the available legal research material. Because when we go to court, particularly I personally feel that I devote a lot of time. In that MP's matter for about 9 months, I stayed up to 4:30 in the night in my chamber. And 3-4% we were almost 2/3 of the day we were working there. But the basic issues which were involved in the litigation, that we were not allowed to address to the court. So that way I feel that the justice will be done only if we are given the sufficient time and if we could elaborate the issues which are involved in the litigation. So far as delays in the justice delivery system is concerned, if we analyze the reasons for delay, basically because if we decide one wrong case, then lakhs of cases are filed. Union of India versus Virpal Singh Chauhan was a case which was decided by Supreme Court. Because of that, of course, we make money out of all those decisions. But lakhs of cases were filed. And similar cases even now we are handling. And still the lower court, they say that still that view in different cases that is prevailing in the judicial system. So with respect, I feel that there should be a uniformity in the legislation as well as on the judicial side. If we don't have a legal system which has a uniform opinion, then perhaps the delays which are corrupting cannot be cured. Secondly, now if we see the litigation at the level of drafting even in the Supreme Court, it has gone very down. Because there are reasons for this. There is no check in the Supreme Court. Earlier, there was, when we came to Supreme Court about 20 years back, everybody used to fear to go to the court. But now everybody is going to the court. Because that type of check which the benches were having is not available today. And I think I'm trying to suggest something.
You will follow that. Give us the suggestion.
I think the Supreme Court should decide that the division benches, when they are deciding cases, that should not be treated as a precedent under Article 140. And in 2004, Mr. Nariman has suggested this, and I agree with him, because the division benches, when they decide issues, sometimes they, with inadvertently or due to oversight, they cases by not considering the material on record. That's why I have a perception that the division bench judgment that should not be treated as a precedent. It should be an inter-party adjudication. Then the ADR system should be applied, alternative dispute resolutions, and by that system we can have speedy disposal. If there are cases between corporations, public corporations and the government, then that should be decided by a committee of secretaries or some higher-ups in the government. They should decide what should be the method to adjudicate, and the conciliation and mediation method should also be adopted. And with this process, the litigation and the number of cases which we are instituting, that will come down, and perhaps the remedy, we will be having the remedy of these delays. Thank you.
Walks to the district court complex every day. Whenever his case is listed in the court, his grievance, the trial is going on for the murder of his son, and it is for 8 long years. Lakshmi Bai, a widow who is working as a maid, had to go to court for last 10 years so that the case of a land which her late husband lived can be decided. Honorable Mr. Justice Tarun Chatterjee, members of the dais, and my dear friends. Many of you can just ignore this as mere illustrations. But if we examine it from our heart and soul, we'll see that these mere illustrations are also reflected in many case laws. The reason for it, if we go on to analyze it, justice is not free. It's a luxury for which you have to pay. It has been said by by Mr. Robert B. Bass, who is a lawyer, who is an American lawyer. Our system provides us that whenever we have clever lawyers among us, the case can be delayed and the rich can go out of it. Mr. President, welcome to the land where our constitution as a whole talks about upliftment of masses and talks about giving the people not just a right to life, but a life with basic amenities which are essential for a dignified human survival. And if a person is aggrieved, its preamble guarantees justice in all forms, that is social, economic, and political. Those who have suffered physically, mentally, or economically can approach courts with great hope for redressal of their grievances. They refrain from taking law into their own hands, and they believe that one day or other they will get justice from the courts. Justice delivery system, therefore, is under an obligation to deliver prompt and inexpensive justice to its consumers without in any manner compromising on the quality of justice or elements of fairness, equality, and impartiality. Before I proceed further to talk on law's delay, we all sitting here should be proud that we are part of a judicial system which shines all over the world. We are a part of a judicial system which is a guardian of the rule of the law and protector of the fundamental rights. The success of the Indian judiciary on the constitutional front is unparalleled. Its contribution is enlarging and enforcing human rights is widely appreciated. Its handling of the public interest litigation has brought its institutions closer to the oppressed and weaker sections of the society. Indian courts are held in high esteem not only by developing but by developed countries as well. There is a widespread praise for the quality of judgments delivered and the hard work being done by the Indian judiciary. Mr. President, Lord Chief Justice of England and Wales, in his fabled speech delivered at the conclusion of the Indo-British Legal Forum meet at Edinburgh, publicly appreciated the enormous amount of work done by the Supreme Court of India in developing the concept of the rule of law and the due process of law enshrined in Article 21 of the Constitution, and also enlarging its scope to extend the encompassing the right to life in healthy environment. The citizens of India can therefore be legitimately proud of this thing. Coming on to the delay context, most of the senior members sitting here have already pointed out what delay exactly is. Being a very junior member of this bar, joined hardly 8 months back, I will think the Mr. President will appreciate my efforts. Delay in the context of justice denotes the time consumed in the disposal of case in excess of the time within which the case can reasonably be accepted to be decided. No one expects the case to be decided overnight. However, the difficulty arises when the actual time taken for the disposal of the case far exceeds its expected lifespan, and that is when we say there is delay in dispensation of justice. The government claims that it is making all possible efforts to deal with the crisis. Even in the inaugural session today, Honorable Minister Bhardwaj said that he has left all the funds to the Chief Justice of India to look into the paucity of funds issue. But, Mr. President, it is not at all reflected in the government's investment policy and its budget. For example, the 2006-2007 budget provides for a $20 billion increase in defense spending, while the government plans to expend a mere 0.08% of its resources on the entire law and justice department, which amounts to a total of just over $45 million. The consistent paucity of resources allotted to law and justice department takes its toll on the potential and efficiency of the judicial system. There are estimated 25 million cases, backlog cases. In 1997, there were 3.18 million cases pending in Indian high courts alone, along with some civil cases taking more than 20 years to reach this court. Overall, judicial delay and inefficiency render public and private rights and obligations virtually enforceable and therefore worthless. No wonder then large corporate firms choose to forego legal redress in India, opting wherever possible for more organized legal systems like that of UK. The recent example is that of two private airlines sorting out their disputes in arbitration in the United Kingdom. Judges are poorly paid, overworked and frequently transferred. It is not uncommon for judges to have a workload that is 500 times that which they are physically capable of achieving. The result is cases being adjourned and postponed. More fundamentally, India has a seriously low ratio of judges per head population, with only 13 judges per million people. Despite More fundamentally, India has a seriously low ratio of judges per head of population, with only 13 judges per million people. Despite decades of government promises to increase this ratio to 50 per million people, even this figure, if achieved whenever it will, would be far less than that of US, which by comparison has a ratio 8 times this figure, standing at 107 judges per million. Court systems continue to spurn transition to modernity and remain antiquated, with hard-kept records and inconsistent classification systems, making it difficult to locate documents and easy to misplace and lose them.